This case starts off like a routine court hearing, but within minutes, it spirals into something way deeper. You've got a defendant already behind bars, stacking charges, unpaid fines, piling up, and a judge who is clearly not in the mood for excuses. What makes this even more intense? The defendant admits guilt across multiple cases, but that's just the beginning. As the judge digs into his history, things take a sharp turn. Past crimes, repeated offenses, and a brutal reality check collide in a courtroom moment you don't want to miss. Stick around, because what the judge says later might completely change how you see this case.
78 22F 237334 20B 136762 20T 635
Your Honor, Michael Crawford representing Mr. Johnson.
Mr. Johnson, your name?
Henry Johnson II, Your Honor.
Well, I got a few files here. And the defendant did not show up for a show cause sometime back in 22. October 3 of 22 to be exact. Where are you at now, Mr. Johnson?
I'm in Wayne County Jail, Your Honor.
I just got to check some things here. Did you?
All right, let's break this down because this part is crucial. The court is going through multiple files, each tied to unpaid fines, roughly $405 per case. Now, that might not sound like much individually, but when you stack several of these together, it becomes a serious legal issue. Failure to pay fines isn't just about money, it can lead to jail time, as we're seeing here. The judge is carefully verifying each charge, making sure everything lines up legally. But here's the real question. Should someone already serving time be hit with additional penalties for not being able to pay? Or is this just how the system enforces accountability?
Figure out what show cause was applicable here.
Your Honor, failure to pay on each of these matters. Original fines cost appear to be $405. We honest 4,510% on each.
So it was 405
Original.
26003A, and then on 36762, I just need to go through each one of these.
Oh, the retail frauds are the same, Your Honor, and larceny.
Yeah. So that was 405. You're saying they're all 405?
They're all 405.
How long's he been in custody?
Well, Your Honor, my client's currently serving a 9-month sentence, one charge, and then a 200-day sentence on another. He's been in custody for 6 months now. My client will plead guilty to all these show causes. He's asking for time served. He can't pay.
Is that what you want to do, Mr. Johnson? You plead guilty to these?
Yes, Your Honor.
This is one of the most important moments in the entire hearing. The judge clearly lays out the defendant's rights, the right to a trial, to question witnesses, to present evidence. And just like that, Mr. Johnson waives all of it by pleading guilty. That's a massive decision. Once you do this, there's no going back, no trial, no defense, just sentencing. And notice how the judge emphasizes that jail time could be imposed on each charge individually. This isn't just procedural, it's a warning. So let me ask you, if you were in his position, would you fight the charges? Or take the guilty plea and hope for leniency?
You plead guilty. I don't have to give you check credit for time served. You're subject to a 93-day jail term on each one of these. Do you understand that?
Yes, Your Honor.
You have the right to a hearing. At that hearing, you have the right to question their witnesses, to bring in your own, to use the subpoena powers of the court to bring in those witnesses. If you plead guilty, you'll be giving up all the rights. We're not going to have a trial. Do you understand that?
Yes, Your Honor.
All right. You still wish to plead guilty?
Yes, Your Honor.
All right. On file 2OB137678 to the charge you failed to pay 405. I don't know how much the fees are now, but I'll just cap it at that for now. Heather, the charge you failed to pay 405. How do you plead?
Guilty, Your Honor.
Did you fail to pay on that file?
Yes, Your Honor.
Is to the charge that you failed to pay 405 on 20B136762, how do you plead?
I plead guilty, Your Honor.
Did you fail to pay on that file?
Yes, Your Honor.
On 20W8260038 to the charge you failed to pay 405, how do you plead?
I plead guilty, Your Honor.
Failed to pay on that.
Yes, Your Honor.
To the charge that you 20T635362 to the charge you failed to pay 405 on that, how do you plead?
I plead guilty, Your Honor.
And you understand when you plead guilty to these that you could get 92 days with credit for any time served, right?
Yes, Your Honor.
Did you catch that shift? The tone in the courtroom just changed completely. The judge starts referencing past sentencing decisions and even calls the defendant a thief. That's not just casual language, that reflects frustration built over repeated offenses. Judges see patterns, and when someone keeps appearing in court for similar issues, patience wears thin. This isn't just about unpaid fines. Anymore, it's about credibility. The judge is essentially saying, I've seen this before, and when that happens, leniency becomes much harder to earn.
But I don't have to give you credit for the time you've been in there. You understand that.
I understand, Your Honor.
It looks like, correct me if I'm wrong, I gave him, well, at least I saw this coming. I mean, I gave
He's
you,
subject to 35 days in jail, Your Honor, on the 4 file we were discussing. 35 days after all credits given. 35 days on.
yeah, I gave him 55 days on those initially, so at least I saw that he was a thief. To the last one, 20T635362, how do you plead?
Plead guilty, Your Honor.
Anybody force you to plead guilty?
No, Your Honor.
Failed to pay 405, correct?
Yes, Your Honor.
Pleas are accepted, all five charges.
Your Honor, I'd like to correct you just for the sake of accuracy. For the filings in 334, the driver's license, and it's 490 about.
Thank you for correcting me. So to that charge that you failed to pay 490, how do you plead?
Judge,
Thank you.
I'm sorry, Judge, I was gonna jump in on that one. The balance that we have in the system for the one ending in 334 is 228.
Is how much?
228,
And that's on file 334.
correct.
All right, so to that charge, you failed to pay 228, how do you plead?
I plead guilty, Your Honor.
Failed to pay on that?
Yes, Your Honor.
Anybody force you to plead guilty?
No, Your Honor.
I don't want to give him credit for time served.
For Your Honor, the court.
I'll accept those pleas. Why is he in custody? Another larceny or
Well, no, Your Honor.
B&E?
Felonious assault, Your Honor.
Felonious assault.
That's the 9-month charge, and then the 200 days is on retail fraud, Your Honor. Will the court consider at least having the sentences run concurrently?
Now we're seeing the human side of this case. Mr. Johnson talks about missing his son's senior year, about wanting to change, about this experience transforming him. And honestly, that's powerful. But here's the harsh reality. Judges hear this all the time. The judge even says it thousands of defendants, all claiming they've changed. So the question becomes, how do you prove it? Words alone aren't enough in a courtroom. Actions, history, and consistency matter. Do you believe him? Or does the judge have a point here?
I'm not doing that. When are you going to grow up, Mr. Johns?
Your Honor, I've been locked up. This is the longest I've been locked up, Your Honor. I'm grown up. I missed my son's whole senior year. You know, I wanted to see him graduate. You know, that's you know, I wanted to be able to see him graduate. Your Honor, I'm grown up now. You know,
You're
this
not
just changed my life.
You're not grown
I've
up.
never been locked up this long, Your Honor, and trust me,
It doesn't sound like you've been locked up enough, if you want my honest opinion.
Your Honor, I'm a changed man.
You're a changed man.
Whether you believe me or not, I am a changed man.
You know how many people have told me, come in here and told me, listen, I just want you to know a secret here. had thousands and thousands and thousands of people appear in front of me. I've never had somebody stand there and say, I'm not going to change. I'm the same guy. I'm going to go out and commit a crime tomorrow. Not one.
No,
So that's just cheap talk to me. That's
Your
just
Honor,
cheap.
Your Honor, God is my witness. I've changed.
No,
I'm a
I
changed
believe.
man.
So he's scheduled to be in how long?
Again, Your Honor, he's got, 3 months left
Right.
on the 9 months, a charge of felonious assault. He's got 200 days on retail.
Retail fraud?
Yes.
Judge DeSanto sent you to jail for that long?
Yes, Your Honor.
I don't know what I gotta, you know what?
This is where things get really intense. The judge openly criticizes the system itself, talking about repeat offenders getting what he calls 841s, essentially benefiting from concurrent sentencing. That's a huge statement. He's not just judging the defendant, he's questioning how justice is being applied overall. When a judge starts expressing frustration with the system, you know this case is hitting deeper issues. It raises a bigger question. Is the system too lenient? Or is it trying to balance fairness with rehabilitation?
I get tired of these 8-for-1s. I get to go out and commit crime after crime after crime, then tell the judge that I'm a changed man and let everything run concurrent. I get tired of it. I'm going to find his criminal history on him. Kind of thick. Kind of thick. I don't really know what I can do, to tell you the truth. I know what I'd like to do.
The felonious assault, Your Honor, is the first felony I've ever been caught. I've never,
Shame on the system. They should have charged you with retail fraud felonies a long time ago. Shame on the system. That's the system's fault. You ought to write a letter of thank you to the judicial, or not to the judicial system, maybe the Prosecuting Attorneys Association of Michigan. Thank you very much for sparing me the outcome of charging me with felonies years ago when I deserved them. You should do that. Do we have proof that he's going to be in for 200 days?
I'm submitting to the court what my client shared with me.
How do I know that? Heather, can you verify that?
Judge, I can try right now. I can't get into anything for county. I'm getting error codes on my search.
Yeah, we're gonna mute you, and I'm gonna go on to another case, and she's gonna check it. Cruz, Dustin Antonio Cruz, 26W841491.
Here, I feel fraud that Mr. Cruz is approaching.
Your name, sir?
Dustin Gleason.
All right, does he stand the waive formal reading?
Yes, Your Honor.
And now he's gonna plead under this ordinance 96-50 with agreed upon, and then the parental responsibility will be dismissed, right?
Correct, Your Honor.
And he didn't write any recommended fines, but on the other one, he wrote 250. The other one, I handled like this. Was there any discussion along those lines?
No, Your Honor, that's the court's discretion.
Sir, if you plead to this violation of civil infraction number 96-50, I'm going to dismiss the original charge. Do you understand that? To that charge, violation code section, Woodhaven Code section 96-50. How do you plead? Responsible or not responsible?
Responsible, yeah.
I'll accept the plea.
Now watch this shift. We move from a repeat offender to a completely different type of case. A parent leaves a 2-year-old at home briefly with a baby monitor just to pay rent next door. The judge accepts the plea, reduces the charge, and assigns a fine instead of jail time. This is a perfect example of judicial discretion. Same courtroom, same judge, but completely different outcome. Why? Because context matters, intent matters, and risk assessment matters. So what do you think was this fair judgment? Or should the situation have been treated more seriously?
Dismiss the original charge. You left a 2-year-old child at home.
Just for responsible, yes. I mean, it was just to pay rent, and my building is literally not even, it's right next to it.
5 minutes. Child was sleeping in when the child up. You have the baby cam on the child.
All right, $250. I'll accept the plea.
That's where you.
$250. You can go down the hall and take care of that. The original charge dismissed. Thank you. Good luck.
Thank you, Your Honor.
Nicole Ann Schultz, 26W841617A and B.
Morning, Your Honor. I'd like to proper representing Mr. Schultz, who's approaching.
Ma'am, you can come on up here and tell me your name, please.
My name is Nicole Schultz.
So she's going to plead to allowing an unlicensed driver to drive. They are going to dismiss the suspend charge, and they are going to dismiss the equipment violation charge. Is that true?
That's correct.
Is that what you want to do, ma'am?
Yes, sir.
If you plead to allowing an unlicensed driver to drive, the possible penalties are up to 500 fines, 93 days jail. Costs are all those. There will be no reporting of this on your traffic record. Do you understand that?
Yes, sir.
Did you sign an advice of rights form today and read it and understand it? If you plead guilty, you'll be giving up all those rights and there will not be a hearing or trial. Do you understand that?
Yes, sir.
To the charge, allowing an unlicensed driver to drive, how do you plead?
Okay.
Were you in control of a 1998 Toyota that was being operated on February 20th, 26 on Goodenough West
Yes.
in Woodhaven?
Yes.
And were you allowing somebody to drive that was unlicensed, and was that you?
That was me.
Are you on probation or parole?
No, sir.
Anybody force you to plead guilty? Please accepted, suspends, dismissed, defective equipment's dismissed. Counsel, anything you'd like to say?
Nothing, Your Honor. My client realized that she made an error in judgment that day. That particular day, she was dealing with a situation where she's a victim of domestic violence. She had to drive herself out of the circumstance. She understands it's not an excuse. She had other choices. She won't do it again. The court should know she's not working.
Was a complaint filed against somebody? So there's a case pending?
Yes.
I thought she got the broken in.
Yeah.
Yes.
What's the defendant's name?
Ronald Atkins.
Is that here?
No, that was in Taylor where it happened.
Go ahead.
So she's not working right now, Your Honor, but she is looking for work. So we just ask the court to take all that into consideration.
I'll go light on you, ma'am. Anything else?
No, Your Honor.
Anything you want to say?
No, sir.
100 fines, 20 costs, 75 victims' rights, $50 justice assessment, 245 or 30 days. How long do you need to pay that?
Your Honor, my client can pay $100 on March the 27th. She can pay $100 a month until it's paid off.
Pay 100 by March 27th. And then you pay 100 per month beginning April the 27th until paid in full. Okay, so you'll only have to make after the March 27th payment. Maybe you can pay the other 145, but anyway, I'll give you that payment plan. Good luck. You're welcome. Good luck.
Yeah.
Dustin Lee Hawk,
Okay.
file number 246W841057. Defendant failed to appear. We have to issue a show cause on this. We'll issue a show cause on this one. Swihart, Aaron Thomas Swihart, 25W390889B. And I also have an A file. Good
Morning,
morning.
Your Honor. Peter Bernardo, P78413, MIDC counsel for Mr. Swire.
Mr. Swihart, your name?
Aaron Thomas Wyhart.
So I have a retail fraud pretrial, and I see he's going to plead guilty on 8089B. And what's going to happen with the other one?
Dismissed, as per Mr. West.
Did he put that on the STIP form?
Your Honor, Josh West, on behalf of the people, yes, the controlled substance would be dismissed.
Okay, yes, I see now. Thank you. So you're going to plead the retail fraud,
Guilty.
Mr. Swihart?
Yes, sir.
That is punishable by up to 500 fines, 93 days jail, costs are all those. If you plead to that, I'm going to go ahead and dismiss the other file, which is the possession of a controlled substance. You understand that?
Yes, sir.
You're presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to remain silent, right to a trial by court, right to a trial by jury. At a trial, you can cross-examine their witnesses, bring in your own, use the subpoena powers of the court to bring in those witnesses. If you plead guilty, you're giving up all those rights, and there will be no trial. Do you understand that?
Yes, sir.
The charge of retail fraud, how do you plead?
Guilty.
I can't hear you.
Guilty.
Were you at Myers on September 19 of 25 on Allender, Carter, and Woodhaven at 8:37 p.m.?
Yes, sir.
You take property that was offered for sale and walk past the register without paying for it with the intent to permanently deprive them of that property.
Yes, sir.
Was that value of merchandise to the tune of about $510?
I'm not sure, but yes, sir.
Are you on probation or parole?
No, sir.
Anybody force you to plead guilty?
No, sir.
Please accept it to this charge of retail fraud. I'm going to dismiss the drug charge. Took $510 worth of stuff. They should have charged you with a 1-year misdemeanor. What do you have to say? What is he in custody for?
Your Honor, Mr. Swire, why are you in custody and where are you?
Probation violation in Monroe County.
Where are you, in Monroe?
Yes, sir.
How long?
9 months.
When did you start your sentence?
October 31st.
So you're about halfway through, right?
Yes, sir.
What's your out date?
As of right this moment, the 25th of May.
Gosh, what are you doing too? How old are you?
41.
It's got to be wearing going to prison and county jails and wherever else you've been. Let me see his record here. Maybe it's in the other files. And I am dismissing the drug charge, which had to do with meth. It's the trifecta here.
Now we're back to a familiar theme: repeat behavior. Multiple warrants, prior offenses, and even a dismissed drug charge tied into the case. The judge calls it a trifecta: drugs, theft, and ongoing legal trouble. That's not just coincidence, that's a pattern. And in court, patterns carry weight. Even when some charges are dismissed, the overall history still influences sentencing decisions. This is why past behavior matters so much in the justice system. It's not just about what you did today, it's about what you've been doing over time.
Problem. You got warrants all over. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13 warrants.
10 of those are closed, Your Honor, as of this week.
You what?
I've closed 10 of those as of this week.
Everybody's giving you a concurrence credit for time served, aren't they?
Yes, sir.
I wish I could figure out a way to not do that. Can't be any fun in there, is it?
Oh, sir.
Aren't you getting tired of spending time? I mean,
Yes, I am a little too old for it.
what are you going to say? I can't do anything else here.
Your Honor, if I could allocate, obviously, because of the length of his incarceration, he's obviously under financial hardship. He's normally, his line of work is a locksmith. He's a professional locksmith. He's been doing that for over a decade. And once he's out, he just will resume that occupation and hopefully will stay on this side of the law.
Anything, Mr. Swihart?
No, sir.
30 days jail. Heather, I'm just 30 days jail, credit 30. There's nothing else I can really do. So we're closing these cases. Good luck. Hope to straighten out your life.
Thank you,
Dozier,
Your Honor.
Anastasia, West.
Josh West appearing on behalf of the people, Your Honor.
Mr. Mays, can you hear me?
Your Honor, I would put on the record, I did speak to Mr. Mays this morning. He did indicate for the record he was still tied up in his other court. If he wishes to adjourn, the people have no objection.
Your name, sir?
James Page?
All right, listen, your lawyer's tied up. He called, asked to give us, you're James Lee Page Jr., right?
Sir.
Your lawyer asked to show up at 11. I said I didn't have a problem with that through my clerk. He's tied up. I'm not going to wait. I'm going to just go ahead and adjourn it. He filed a motion, so I'm going to ask you guys to respond to that, okay?
Yes, Your Honor.
So we'll adjourn it to, what is it?
April 1st, Judge.
What time are we going to do? Let's make it 8:30, okay, Heather?
Okay.
At 8:30. So tell your lawyer we're adjourning it to that day. I'm going to ask that you guys file a response to defendant's motion to be filed by March 26th.
Yes, Your Honor. I'll see to it. Thank you.
Okay? You can go down the hall. We'll give you a notice. Call your lawyer. Tell him what happened, okay?
Okay.
Thank you. Do we have did we find out anything about
This courtroom session gives us a powerful look at how justice really works, not just in theory, but in practice. We saw a repeat offender facing the consequences of ongoing actions, a judge clearly frustrated with both the individual and the system, and contrasting cases where context completely changed the outcome. The key takeaway: the legal system isn't just about rules, it's about patterns, decisions, and accountability over time. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.